Good morning, everyone. Happy Monday. I am Carol Williams with Williams Immigration, and we are back with another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So I, as you know, like to dive right on in. It has been a little bit of a busy weekend. As usual, USCIS actually, this time not USCIS, more so the White House dropped an executive order on us Friday, as most of us were leaving for what we thought was going to be a fairly uneventful weekend, but alas, not the case. So we had an executive order that added a new fee to the H-1B to the tune of $100,000. Yes, that's right, $100,000 for the H-1B. So a quick summary of the weekend for most folks in global mobility, HR managers, H-1B sponsored beneficiaries, folks that that are currently going through their H-1B application. Maybe they're in the middle of a renewal period, and outside counsel. So our weekend looks a little bit like this. So Friday, we got the executive order. We read it Friday through about Saturday early evening. There was sort of a state of panic where businesses and attorneys started asking a lot of questions about the language in the executive order. People started to call this executive order effectively a travel ban for individuals in H-1B status or individuals looking to enter the U.S. in H-1B status, where they couldn't enter past Sunday without paying the new fee. So people kind of felt like this came out of nowhere. If you are currently outside of the U.S., the anxiety levels were quite high. Some folks moved their flights around. Some folks flew in early. Those that couldn't move their flights were just worried. Lots of anxiety. So Saturday, late afternoon, early evening-ish, USCIS issued a memo with the intent to clarify the executive order and essentially address a lot of the questions that had come up since the drop of the executive order on Friday. And the memo states, I'm going to just read it. It's fairly short. The proclamation only applies prospectively to petitions that have not been filed. The proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date of the proclamation, are the beneficiaries of currently approved petitions, or are in possession of validly issued H-1B non-immigrant visas. All officers of United States Citizenship and Immigration Services shall ensure that their decisions are consistent with this guidance. The proclamation does not impact the ability of any current visa holder to travel to or from the United States. So that is what the USCIS guidance said that was put out on Saturday. Still a whole lot of questions that we have. I don't expect them to be answered this week even. So if you are currently in H-1B status, you are thinking about H-1B status, you are in the middle of your H-1B application, it is crucial that you give your global mobility team and your attorneys time to look at your case specifically, and really do our analysis of the executive order and this new memo that is supposed to clarify the executive order. We may get more memos that, more so clarify the executive order. We'll see, but that's kind of where we are. And we'll see what happens after that. But we are all working quickly, as quickly as we can, to figure out whether or not our current strategies need to be changed for all H-1B cases. So that is how most of us, like I said, in global mobility, folks that have H's, folks that are applying for H's, and outside immigration attorneys spent our weekend. But that wasn't the only thing that happened. So over the past week or so, we still have some other things that I want to tell you all about. So the naturalization test is looking to get harder. It will increase the number of possible questions from 100 to 128, and you will need to be able to answer 12 out of a possible 20 of the civics questions correctly. This notice was effective September 18th, so just a couple of days ago. So anyone that files on or after October 20th, their naturalization cases, they will be subject to this new 2025 rule with the increased questions. If you filed before that, then you'll be under the current rules. Now, maybe current, maybe some people will refer to them as old, but you'll be under what we call the current rules. The English test still remains. So you still are going to have to show that you speak, read, and write English. Those parts haven't changed. But the Immigration Service has said that this is sort of like going to be like a slow rollout of changes to the naturalization application. So those are the changes that we're looking at now. This change comes on the heels of the good moral character change. So we'll see what changes are made next. The next thing I want to talk to you all about are social media handles, accounts, identifiers, however you want to think about them. They are already asked for on your DS-160 and your DS-260. Those are your non-immigrant and your visa immigrant applications. And so DHS is now wanting to ask those questions, ask for your social media handles on the application forms that it handles. So all the forms that begin with I. It is actually extending the comment period. So we'll see what they say about that. But the forms that they are looking to add the social media handles would be on the I-131, which is your travel permission form. It's used for a couple different versions of travel permission, but a lot of people use it for advanced parole. The I-192, which is used for T&U applicants. The I-45, which is the adjustment of status application, which is green card. The I-589, which is used for asylum applicants. The I-730, which is used for refugee and asylum relative petition. So someone is bringing over relatives when they have already been approved for refugee and asylum, then they're sponsoring their relatives. The removal of condition application, which is the I-751, and the I-829, which is the petition by investor to remove conditions on permanent resident status. So not all of the I form, not all of sort of your USCIS forms are part of this. It's like they're trying with maybe a small sample size, maybe looking to see how it goes. Maybe they'll extend it later. We don't know. But that is coming at us. So keep that in mind. The EB1, EB2, EB3 have all reached their limits for this current fiscal year. So we're not going to see any approvals of green cards that are EB1, 2, or 3 until the new fiscal year. So we have a week and a half now until the new fiscal year begins on October 1st. So just got to kind of hold in there until October 1st. And then we should start seeing approvals coming at us again for employment-based green cards. That is all I have this Monday morning. It has been quite a long weekend with the executive order, but I'm here to help keep you guys up to date. Hopefully this has been helpful. Feel free to reach out to the office if you have any questions, you need help with strategizing your H-1B case or looking for alternatives to H-1B. We're here to help. So again, I'm Carol Williams with Williams Immigration. Have a wonderful rest of your Monday and a great rest of